there has to be some common sense.
Yes, sir. They have the car stopped at 10th and Ranch by Kohberger.
We still don't know who pulled the trigger.
Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. Before we get into today's show, I'd just like to wish all you fathers out there a happy Father's Day, one day late. Also, today is Monday, the June 19th, a happy Juneteenth. Many things to celebrate. We've been off the air for a little bit. You know, sometimes life gets in the way of these Police Off the Cuff broadcasts, and we miss you guys. If you miss us, we appreciate that, but we definitely miss doing this show and just giving out the information and just coming to our audience and delivering the real crime, the true crime from a police perspective in the way that we do. So tonight what we're going to talk about is, again, there's so many different moving parts in the Brian Kohberger, of course, the Idaho quadruple case of Ethan Chapin, Zana Knodel, Madison Mogan, and Kaylee Gonsalves. And I always like to mention their names because they're not the Idaho Four. They are real people with real names. Anyway, what we've been noticing, and from our perspective, again, from a law enforcement perspective, the only one out of the three people that are going to be on the show tonight that has a law degree that's qualified really to speak in depth about the law is Mike Geary. So I just let it out of the bag. He's on the show tonight. Yes, he's recovering from Father's Day, and he's going to be on the show tonight. And it's great to have him here. But one of the things that we've noticed the defense doing, it seems like they're doing a lot of what we would call the old Dean Smith four-corner offense with North Carolina, the stall. They're doing a lot of stalling, it seems, because they're trying to get more time. And in regards to stalling, what we believe they're doing is they're trying to have the prosecution play defense, really. And the prosecution, to put it in a sports sort of vernacular, the prosecution is on offense. And they're constantly trying to move forward with this case and prosecute it. But at the same time, there is strategy involved. And they don't want the defense to know everything they have and to know all the moves they're going to take as prosecutors. And all these moves they're going to make strategically within the parameters of the law, within the law, is perfectly legit and perfectly legal. I watch a lot of people on, on YouTube, and even the talking heads, they talk about, oh, this isn't right. That isn't right. Believe me, the prosecution wants no part of the possibility of an appeal to this case. Therefore, they're going to cross their T's and dot their I's, and they're going to do everything correctly in this case. But at the same time, the defense's job is to try to create doubt. And Ann Taylor, who is the lead defense attorney in this case, is going to use every trick in her bag of tricks to try to create doubt and to try to get an advantage to her client who is on trial, who is going on trial. Again, the next court date is October 2nd. And we all realize everyone was sort of looking forward to June 26th, which was going to be the date of the probable cause hearings. And we all sort of, in a way or in a word, had the rug pulled out from underneath us with these secretive grand jury proceedings. And when a lot of people report on secretive grand jury proceedings, they're acting like it's an illegal thing. Grand jury proceedings are always secretive. The only difference I could see here, I think from what we're used to in New York, is that grand jury proceedings, they allow the defense, if they wish to testify. So I don't know if this was ever offered, apparently not, or the defense wouldn't be sort of crying out right now like this was unfair. We didn't get a chance to know that you were going to a grand jury with this evidence. And had we known, I doubt seriously they would have ever had Brian Kohberger testify. But they can pretend that they were going to, like, as if something was done improperly. So you guys have listened to me for the first 5 minutes and more. So I'm going to bring on our guests one at a time. And first, professor, law degree, retired NYPD sergeant, a professor at Albertus Magnus College in Connecticut. We have the great Michael Geary. Welcome to the show, Mike.
Billy, thank you for having me on. Good evening.
Mike, are you trying it without your glasses tonight?
Yeah, I got them right here. I'm trying to look younger.
You got you close by because I can't see the screen without my glasses on.
I'm getting there.
We also have with us tonight retired NYPD detective and straight out of Brooklyn. He's even wearing the black shirt. Phil Grimaldi. Welcome to the show tonight, Phil.
How you doing, Billy? And I wanted to say happy belated Father's Day to all. I hope every father had a great Father's Day yesterday.
I said that with the opening, and I know that 74% of our audience is women, and I don't want, I know you guys had Mother's Day, and I wished you guys a happy Mother's Day, so I don't want to not acknowledge all the women that we have as our subscribers, our fans, and our audience, because they are the biggest part of our audience here at Police Off the Cuff. So, guys, I just wanted, I'm going to address Mike first. Mike, we've seen so much about this, the defense, and of course it's Ann Taylor, the lead defense attorney, basically protesting the secretive nature and trying to come out against the prosecution as if something was done incorrectly. They're always crying out about discovery. They're not getting what they asked for in a timely manner. They're not getting everything they asked for. They're not getting it in a timely fashion. You want to address that a little bit, Mike?
Billy, there's so much evidence that the prosecutor has in this kind of case, because you had the Moscow, Idaho Police Department investigating, you had the Idaho State Police investigating, you had the FBI investigating, and there's a lot of witnesses' statements, there's a lot of video, grainy video, you've got a lot of crime scene evidence, you've got a tremendous amount of, obviously, what we consider some of the most important would be the DNA evidence. So there's all this evidence, and the prosecutor is always on their front step because they're the ones who are moving forward, as you say. They've got all of the technical expertise on their side. And when after he was arrested and they began turning over all of that material slowly to the Kohberger defense team with Ann Taylor, they're on their back foot and they're reeling from the amount of evidence that's being turned over. In here right now, instantly, we're talking about the grand jury hearing, and they were not expecting a grand jury indictment. The defense was expecting to have a preliminary hearing, a probable cause hearing, in front of the judge, where they would actually have live witnesses in front of them testifying for the prosecution, and they would have a really good serious run at them, and they could maybe look for some chinks in the armor, some weaknesses in their case, maybe some investigators and scientists and crime scene analysts that may have not be the best witnesses, maybe unsure. They would have a little run and they could see some of the strengths and weaknesses of the prosecution's case. Like everyone here, we were taken by surprise that they went to a secret grand jury, but I seriously doubt whether Ann Taylor had no idea that a grand jury would be convened in lieu of the probable cause hearing. So, what she's doing right now, she's doing what every good defense attorney is doing. And you and I and Phil would be doing the same thing. We'd be pounding the table, claiming that we're being prejudiced because the grand jury minutes weren't being turned over fast enough, and we want to see some of the reports that were being discussed in the grand jury. So she's doing her job. She's doing her job, and I don't think anybody should really worry that in the audience no one should really worry that, Mr. Kohberger is going to be set free and the charge is going to be dropped and the indictment is going to be thrown out and things like that. Not at all.
Mike, just one question before I go to Phil and ask him a couple of questions. What about the only thing I could see that the defense could really have a grievance with is that claiming that they wanted to testify and they were not afforded that opportunity. Would that be a legitimate complaint? And is the prosecution required to notify the defense in order to allow them the opportunity to testify?
Yeah. With states that have grand juries, not all states have grand juries. I think like Montana has just a probable cause hearing, especially the more rural states, because you have to have like 20 people in a room and you're paying them, things like that. But if a state has a grand jury system, then the prosecutor is supposed to give notice to the defense attorney that they will be convening a grand jury and offering the defense attorney the offer to have the defendant come and testify. And the defendant would testify, and the defense attorney could be in the room but could not help out. And no defense attorney really worth their salt would want that to happen. Maybe in a few real singular cases, unique cases, would a defense attorney avail themselves of the invitation to have their client testify. But I'm sure Ann Taylor knew that the grand jury was being convened, and there's no way that if invited, she would ever want Kohberger to testify. Absolutely not.
So Mike, is that then she probably knew there was a grand jury, she was notified, but now, as per perhaps the gag order, she didn't blurt it out to the press or to anyone else. She had to keep it to herself, but now she's acting as if she didn't even know about it.
Well, she's one of the things she's claiming is that the grand jury wasn't convened properly, that she wants the names and addresses of the grand jurors. I think she really does want to speak to them, have an investigator speak to them. She's claiming that the surrounding publicity makes it difficult to convene grand jurors, just like trial jurors, convene grand jurors who have not yet formed an opinion as to Brian Kohberger's guilt or innocence. And she's claiming this is all prejudicial to him. And she wants
Mike, I got to interrupt real quick.
Yeah.
I apologize, but it's a secret proceeding. Does she have the right to know the identities of the jurors? Is that one of the protocols that's in place with grand juries?
Well, that's very abnormal. I've never heard of that.
I thought so.
In New York. I can't speak about Idaho custom in their criminal procedural, but in New York, it doesn't matter if it's any felony. It could be a burglary, robbery, assault, murder. I've never heard of a defense attorney ever being given the names and addresses of the grand jurors.
Exactly.
Never.
That's the point.
Yeah.
Okay, good. That's
I
the
think
point.
she wants that because I'm thinking she's fishing. She's on a fishing expedition.
Yep.
She'll have a detective go out there, an investigator, and interview them and try to perhaps talk to them and see if they can get some sort of, one or two quips from one or two grand jurors and say, look, we kind of already knew he was guilty, but even if you successfully challenge under Idaho criminal procedure law, even if you successfully challenge one grand juror, so long as there's 12 who vote to find that there's probable cause, the indictment's still good. She would have to successfully attack a whole number of grand jurors. I don't see that happening.
Well, we just lost Phil, but I was just going to go to Phil and ask him a couple of questions. But some of the things that I saw, some of the notes from the grand jury that they objected to was the potentially the grand jury makeup, and there obviously is no voir dire. I hope I'm not a French student. I don't know if I pronounced that correctly. I guess it's passable for a New York cop. voir dire, but that's when both sides gets to choose the jurors or gets to exclude and include jurors And in this case, with a grand jury, there's no voir dire because it's only the prosecution. I think Phil's back. It's only the
Yes.
prosecution picking it. Phil, I just wanted to go to you too. We spent a lot of time with Mike. I want to give you a chance to,
Okay.
especially that black shirt is very intimidating, and the fact that you're from Brooklyn. You
Watch
people that
out
are
now.
listening, you're
Watch
not getting
out.
to see Phil's intimidating black Brooklyn shirt. It's no collar. It's very intimidating. So we're going to go to Phil right now. With this grand jury, Phil, it's amazing that you can hear a lot of people say, "Oh, they're going to get this grand jury thrown out." What is the possibility of that?
I think the possibility of that is probably very low. And I just want to explain a little bit about the grand jury system. Now, the grand jury is not a trial. You know, someone gets arrested, there's enough evidence put forward that police officers have now made an arrest. In this particular case, it's a quadruple homicide. Prosecutors are involved in the investigation, so they probably authorized the arrest. There's a lot of information that went into this case, a lot of evidence. So now we're going to put specific pieces forward to a grand jury to see if the grand jury will vote to indict. What that means is that now we're taking it to the next level, the next step. The proceeding will go from an arrest situation to an indictment, and it will go continue now further down the line. The trial process will begin. The trial process will include evidentiary hearings, and then we'll eventually have the trial. Now, if there was some type of mishandling of the secret proceeding and a defense attorney can prove that, perhaps they can get that indictment thrown out. And I think very quickly, again, Mike alluded to it, that there would be another grand jury put in place, and more than likely Kohberger would be indicted. There's a saying that we've said in New York, and it's been mentioned many times in the media: you can indict a ham sandwich. The meaning of that is not that you can, that it's so frivolous that you can indict a ham sandwich, but it doesn't take a lot of evidence. It doesn't take a lot of testimony to be put forward based on now when an arrest has taken place that we want to move forward with the process, the criminal procedure process in the United States, the criminal justice system that's in place. We want to proceed with it. So it's kind of like a funny thing. You can indict a ham sandwich, but what it means is you don't need a lot of evidence put forward to get that indictment. There's enough there that we think, okay, this process should now move forward. Now, if there was some protocols that weren't met, it wasn't secret, or perhaps there wasn't enough jurors. I don't know what the defense attorney, Ann Taylor, is getting at, that she wants to challenge it. Or perhaps, and we don't know this for certain, it was a gag order. Maybe she was never notified that the grand jury was going to be put in place. And again, Mike alluded to it, that perhaps, he's given the right, Kohberger would be given the right to go in front of that grand jury and testify. I think it would be extremely unlikely that that would be in place, because now the prosecutor in the case would get to cross-examine him about some of the things that already been put forward in the media, some of the evidence. So I doubt highly that would be the case, that a defense attorney would do that in this particular case. However, in some cases, there are times when a defendant does go before the grand jury. One last point, Mike, I have to agree on what you brought it up. If there was no grand jury and it went to a hearing and there were people testifying, yes, it's not the trial. You get to challenge that witness. You get to go at them, and you get to hit them with some hard questions. Perhaps they get rattled. You can also, the defense team would now be able to assess that witness and say, well, they were not good in their testimony. We can attack them on this. We can attack them on that. So perhaps it was a bit of a chess move to do the grand jury as opposed to go right to that hearing. But I don't think it was improper. It was probably legal in every way, shape, or form. The criminal justice system we know in this country, that we use in the New York area, the grand jury would have been something that would have happened within the first few days of the arrest.
I just want to play a little bit of this here.
Proceedings, as well as requesting the release of grand jury transcripts. Brian Kohberger's attorney says it's his legal right to challenge that grand jury indictment and should be allowed access to all relevant materials, which is why he stood silent rather than entering a plea on May 22nd. They argue he needs more time to go through the information. He was indicted by a grand jury on 4 counts of first-degree murder and 1 count of burglary. A not guilty plea has been entered on his behalf. Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle were found stabbed to death in their off-campus home on November 13th. Kohberger's trial is expected to start in October.
So we know very well that excuse me, let me just remove this. We know very well that there's no chance on earth that this case, the actual trial, is going to start on October 2nd. That is a date I think that the judge has to pick dates that we got to keep this thing moving forward. And they will show up on, there's no doubt everyone's going to show up in court on October 2nd. And the first thing, or if it's not the first thing, but one of the very first things the defense and Taylor is going to do, she's going to go up to the judge with the prosecutor side by side and say, I need more time. I'd like a stay. And I'd like a stay. Well, right now it's October 2nd. I'd like a stay till February 2024. You know, we've said this before all of these motions have even started. That is what's going to happen. This case is not going, I predicted it would probably go in late 2023, but now I'm pulling that back. I think we're seeing it's not even going to get off the ground till 2024.
Bill, can I make a quick point about
Go
that?
ahead.
I think that you're 100% right. I think what may happen is, the judge has a responsibility to keep things flowing. So when they go to court, perhaps that defense attorney is going to make those arguments that we need to examine more evidence, this and that. But perhaps the judge might say, okay, well, we're going to start looking at the evidentiary part of this, have a hearing on challenging evidence, or they may do other things connected to the trial. Now, you may not have the actual trial, like you said, Bill, and I agree with you 100%. It's probably going to be sometime next year. I'm predicting the spring of next year, perhaps late winter, early spring, like you, Bill. And we don't know. It could go even further than that. But I think that something is going to happen with regard to this case on that next October 2nd date, whether or not the judge might say, okay, for the next couple of days, we're going to hear different pieces of evidence. We'll challenge them. We'll have both sides, and then I'll make rulings. But we're not going to see the trial. I think that's almost a gimme on October 2nd.
Mike, we had talked off the air before, and you spoke about it, which were very important, exculpatory and inculpatory evidence. And everyone gets to learn from the professor now, because those are awfully big words. And thank God I understand what they mean, but everyone that's listening may not. So I want you to explain that, and also explain from the prosecution's point of view why they have to also present exculpatory evidence.
Great. Thank you, Billy. Exculpatory evidence it's just a fancy word for evidence that tends to prove that the defendant is not guilty of the crime, that they are innocent of the crime, that there's a lot of doubt as to their criminal liability. That's exculpatory evidence. Incriminating evidence, or we call inculpatory evidence. You can always use the term, incriminating evidence. That's fine. Incriminating evidence, inculpatory evidence is evidence that tends to prove that the defendant is guilty as charged. Now, Ann Taylor has made mention of this before about the amount of evidence that she's getting and being overwhelmed about the evidence, and she's claiming that there's, I think she made a mention to the judge. There's a motion, and there's going to be a hearing next week on trying to force the prosecutor to release a lot more grand jury information. And she's claiming that she really can't even offer an alibi because she was supposed to let the prosecutor know that deadline has passed. She was supposed to let the prosecutor know that if she was going to offer an alibi for Brian Kohberger, but she's claiming now that there's so much evidence and she's waiting for more evidence, and she really can't even begin to come up with an alibi that she could present to the prosecutor. That seems like it's just a real stall tactic. But that's just another thing that is on the plate, is going to be on the calendar, I think, for next week's hearing on her motion to force, to compel the prosecutor to turn over all the grand jury information, is that the prosecutor is probably going to go right back at her and say, hey, you're already over the deadline for letting me know whether or not you're going to have an alibi witness. And so, you're violating criminal procedure law. So there's going to be a lot of, tit for tat going back and forth. That's the gamesmanship, but a prosecutor is, there's something called the Brady rule and it's a rule that was devised by the United States Supreme Court, and of course all state courts follow it, is that all evidence that the prosecutor gathers, whether it's inculpatory or exculpatory, must at certain times be turned over before the trial begins. So if there's evidence that tends to show that Brian Kohberger is innocent of the crime, the prosecutor can't bury that evidence. They actually have to turn that over to the defense, and the defense would be very happy with that. And that's considered part of our basic fairness, our basic due process fairness. I will say, under Idaho criminal procedure law 6.1, if a prosecutor in front of a grand
Mike,
jury,
you did your Mike. You really did
I'm
your
telling
homework.
you, he really did.
He studied and everything. Look at that.
Yeah. Under 6.1 of the criminal procedure law, if a prosecutor who's presenting before a grand jury is made aware of exculpatory evidence, substantial exculpatory evidence, the prosecutor must actually present that to the grand jury, and then, of course, turn it over to the defense attorney. Now, what the prosecutor thinks is exculpatory, meaning tending to prove that Kohberger is innocent, may be very different from what Ms. Taylor thinks as a defense attorney is exculpatory, tending to show Brian Kohberger is innocent. We've talked about this many times, and you and Phil have done this. You interview 20 to 30 people, witnesses, partly in a criminal investigation of a homicide, and some witnesses will contradict each other about time, place, things like that.
And that's normal. That's normal in cases too, Mike. It's expected sometimes. If everything's exactly the same, something's not right. So you want certain inconsistencies, but the major points, if there's major inconsistencies, then that presents itself as a problem.
But I just want to mention one thing. One of the reasons that a grand jury is secretive is to protect the identity of witnesses, because in many areas across this country, especially in New York City, that was our experience. A witness was terrified to go and raise his right hand in front of the grand jury that his name could get out, because in his neighborhood, he or she, they signed their death warrant. If someone in a shooting or a homicide case found out that so-and-so just testified against them, believe me, witness intimidation in the neighborhoods that we worked was just happened all the time. So when that happens, people that live in those neighborhoods, they talk to each other. Don't you dare testify. They'll get you, and that's a real thing. It's a real thing.
Yeah. So if you have a couple of witnesses who make contradictory statements, we talked about BF, Bethany Frankel, things like that earlier, a couple weeks ago, a good defense attorney is going to claim, pound the table and claim that is exculpatory evidence. There are contradictions within the case folder, and that in and of itself should have been presented to the grand jury. That's almost like akin to being misconduct if the prosecutor never presented it, and it should void the grand jury indictment. We should start all over again, and just make a lot of hay over this sort of thing. She's doing her job. She's doing the best she can.
Phil, have you ever seen in your police career a grand jury nullified and then say that they throw out the indictment?
I would have to say no. I've never seen that. I know that sometimes grand juries were put in place, and their time frame that they were in place for ran out, and they would have another grand jury due to maybe things that came up in the investigation, a roadblock, or they were trying to get more evidence. And so sometimes the grand jury that was seated for a certain number of days. The term expired, so they put a different grand jury in. But I never seen where a grand jury was where the indictment was overturned, and then they went into a different jury. No, I never did see that. But I just want to make a quick point about some of the stuff that Mike just said. You're talking about whether or not the perception of the prosecution with regard to exculpatory evidence as opposed to defense, they may be very different. I agree with you, Mike. But that's where the judge comes into play, because the judge is going to say, he's going to make a ruling. Well, this seems reasonable to me, or this is unreasonable to me. And I think that's where you have both sides, and you have the judge, and they're all experts, and they're all, known in their field. So again, these are all the components of the jury system in the United States, and that's what's going to take place going forward in this case.
Mike, there's a great question from the chat, Jesse Essex. If the prosecution fails to show exculpatory evidence of one element of the crime, the defense can challenge the indictment. Is this why his attorney is asking for the evidence? She wants this info.
Yeah. Ms. Essex, I think that's a great question. Yeah. There's enough information that is in Ann Taylor's, possession at this point to say, wait a minute, this to me is exculpatory. I want to know if this bit of information that I think as a defense attorney is exculpatory, was that presented to the grand jury? And if it isn't, I want that grand jury indictment quashed. I want we're going to start all over again. And and Phil's right. It goes to the perception of the prosecutor and the defense attorney, what they think is exculpatory. Obviously, the defense is going to think a lot more is exculpatory than the defense attorney. And Phil's right again. The judge is going to make the final determination, because I think next week, I think it's a week from tomorrow, they're going to have a hearing on this motion to compel, and the judge is going to make some rulings. And my guess is he's going to be very conservative and not, start, kicking down, previously held customs and usages within Idaho for when what's considered exculpatory or inculpatory and what deadlines there are. I think he's just going to rule basically like we would see in a New York courtroom that, thank you very much, Ms. Defense Attorney. We appreciate that. Mr. Prosecutor, what do you have to say? And I think after, an hour-long argument on both sides, he's probably going to judge is probably going to say, look, I'm going to vacate your motion. By the way, let's get on with it. We got a lot of work to do. And I think in the end of the day, after, an hour or two of wrangling, that's what the judge will do. And we'll just be continuing one step closer to the trial. Now, remember, just even if that happens, like I predict, it doesn't mean that can't be grounds for appeal later after the trial's all over with. Once you make an objection, that will preserve your ground for appeal in the future. So even if this goes to trial and, we're in the summer of 2024, if Mr. Kohberger is convicted, there's going to be an appeal. Obviously, there's going to be numerous appeals in this case.
Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, then you're in the right place. And if you're not subscribed to us, go on our YouTube. Hit that subscribe button. It's free. Give us a thumbs up and ring that bell. Make comments. We love reading your comments. We love answering your comments. And if you want to support us financially, we have a Patreon with 3 different levels. We also have a YouTube channel memberships with 5 different levels. And you see the folks in the green font. They're part of our YouTube channel member family. And they support us, our fans, our friends, our subscribers, and we really appreciate them. So, yeah, I can't help but think, again, that this is almost, we use sports metaphors. This is a Hail Mary pass by the defense. This is a stall by the defense. They're not ready. They're not ready with the overwhelming, and we said that one other time, and I was attacked by half of the YouTube audience. What do you mean? I said the overwhelming amount of evidence that I believe the prosecution has. Again, we spoke about exculpatory evidence. We don't know about all the exculpatory evidence that if the prosecution has it, of course, they must turn it over. If the defense has it, they're not talking about it because I don't believe they have it, And then there's a lot of noise out there of people talking about exculpatory evidence that truly doesn't even exist. Phil?
Well, Bill, I just wanted to make some comments about the courtroom drama, because that's one of the things you put in the title of today's show. The only drama that I see is his demeanor. That when he's been in court, his demeanor has been. I mean, I wrote this down. His demeanor has been strange, unusual, and he seems very aloof about it. Now, I mean, if you're being accused of 4 homicides in this very, very gory and violent manner, I think your demeanor might be a little different. So that's one of the things that I think really jumps out at me. And with regard to whether or not we believe his guilt or innocence, we're not saying it from such an amateurish point of view. Now, I've spent most of my adult life in law enforcement. Sergeant Cannon as well, and Mike Geary as well. We've all spent most of our adult lives involved in law enforcement. So when we make a statement or we give an opinion about this case or about evidence, it's based on years and years of experience. So again, in the criminal justice system in the United States, everyone is presumed innocent until proven guilty in a court of law by a jury of their peers. So I believe that Brian Kohberger should be afforded that presumption of innocence. However, what we know about this case and what we know that's been put forward already, we in law enforcement can come to that conclusion that we feel this is the right guy. Now, that's where the trial comes into place and all the things that are going to take place. The hearings to challenge the evidence, and a good defense attorney is going to be doing their job. And this is one of the things that this particular defense attorney has latched onto, that to challenge the grand jury part of it. So again, I know people have gotten upset in the chat, and Melanie put forward some great questions the other night, convinced me with the evidence. And we went back and forth a little bit. And I think that people are right to have that opinion that he's innocent until proven guilty, 100%. But we're not saying the things that we're saying based on, just pulling it out of thin air. There's a lot of evidence here that we know about, and we know there's a ton more that we don't know.
Absolutely. I want to play a little bit of News Nation Ashley Banfield here.
We want more time to look through all the stuff that the grand jury did, said, all that secret stuff, because we think it maybe didn't go according to law or plan, or there was something hinky in there, which means we want to toss it out. We want that grand jury indictment tossed out. Grand juries are secret, and they really are a prosecutorial process. They're not a defense process. So this is interesting. I like the way she thinks. This is what she says. She says, Kohberger is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. While the matter of the grand jury record is argued and prepared, she wants more time to go through with a fine-tooth comb. Here's something else that was interesting. She said the grand jury was impaneled at a time when the small community of Moscow, Idaho, had been exposed to 6 months of intense local, national, and international media coverage. Because the state has provided extensive discovery, Mr. Kohberger knows that exculpatory evidence exists. That's interesting. Whether a fair and impartial panel of grand jurors was assembled amidst intense media coverage is a significant question the defense must evaluate. Well, that is interesting. So that's why I get the interesting guest, Mark Garagos, trial attorney, co-host of the podcast Reasonable Doubt with Adam Carolla. Let's start with the money. Mark Garagos, $135,000.
I just want to mention something, Mike, and we spoke about it before, is that, again, it seems like a stall. I've never seen anyone challenge the grand jury indictment, because there's so many more levels to go after the grand jury. There's going to be hearings, there's going to be this, going to be that, and then at some point you get to the trial. But if she's going to challenge the grand jury, true bill, the indictment, what is, I mean, this case could take 2 years. You know, I mean, it's sort of, to me, ridiculous that she's challenging this.
Yeah, it seems from what Ashley Banfield said, it seems that she wants more information from the prosecutor so that she can assess whether or not there are grounds to challenge the grand jury's finding of, probable cause. Because as she said right before you cut to it, that this has been 6 months of intense media coverage, which has nothing to do with the prosecutor. Prosecutor does not create the media coverage. So she's buying more time. She wants to say, look, I need weeks, I need months to determine on my own, from a defense attorney's point of view, whether or not there really is grounds for an appeal, because I believe that there must be, exculpatory evidence out there. And I believe that the formation of the grand jury was improper somehow. She's just looking.
Mike, we hear it all the
weeks and
time
months.
in court. We hear it all the time in court when a prosecutor says, Your Honor, the defense is just going on a fishing expedition. They always use that expression. And that is exactly what the defense is doing right now. They're going on a fishing expedition to discover. It's almost like playing cards and asking the guy next to you if you could see his hand.
Yeah.
You know?
Yeah. And then so this might be weeks, maybe she's looking for an extra couple of months, because, look, she's doing the best she can. This is her ethical obligation to zealously advocate for her client. And she's a great attorney. She's done death penalty cases before. She probably has worked in the prosecutor's office. She knows the prosecutors. They've all challenged each other in court. They've all faced each other in court. She knows what she's doing, and she's doing the best she can given this. I bet you this is probably the greatest amount of incriminating evidence she's ever seen compiled for any of her clients in the past. And she's overwhelmed
Absolutely.
by it.
Let's see what Garagos says. A little bit of Mr. Garagos here.
$1,000 for a quadruple murder case. How much more is it going to go up from that? They can't possibly stick to that budget, can they?
It's going to go up quite a bit. And by the way, that's probably why people are fleeing California to go to Idaho, because the cost of living or prosecuting is much cheaper there. I'll tell you, the defense cost alone in a capital case in a place like California or New York is a multiple or exponentially more than that.
Yeah, the prosecutor, Bill Thompson, said it's hard to project exactly what's going to be involved. We know that it's not going to be cheap. That is the understatement of the century. All right, let me ask you about this whole challenge to the grand jury process and maybe the indictment itself. I love it. It's like spaghetti. Just toss it and see what happens. But how often does this trick work?
Well, it's not so much a trick, I think. And I looked at what she wrote, and I think what she's doing is setting up a situation. When you have a grand jury in most jurisdictions, and both in federal and state court, you have to give the defense the opportunity to present exculpatory evidence, if you will, once the grand jury is happening. And that can be what you just kind of recounted, was whether or not the grand jury was selected impartially. So that's a different challenge. The challenge to exculpatory evidence is, I believe what the argument, they're laying the groundwork for the argument is, hey, we know that there's exculpatory evidence. We didn't get a chance to present that. That is our right. Even though it's a secret proceeding, we do have the opportunity, just like in New York, where you and I talked about in the Penny case, where he could or didn't, or we don't even know actually whether he testified in front of the grand jury.
So Mike, going back to what I said before, and they're challenging that the grand jury was secretive. They didn't have the opportunity to pick the grand jurors, which I don't believe the defense ever gets that opportunity. There's no, as far as I know, there's no voir dire, again, pardon my French, in picking grand jurors as there is in trials. The other thing is that you were pretty confident to say that you believe that Ann Taylor was notified that there was a grand jury. And then if that's the case, that would have afforded her the opportunity to present exculpatory evidence or to have Brian Kohberger testify. So what is the argument then?
I think the argument is that she's the publicity. There was so much publicity that you really can't seat, under those circumstances, a grand jury that actually is a grand jury made up of people who have not yet made up their mind as to whether or not he's guilty. And this issue is going to come up again at the actual trial when they go to the voir dire and they start picking the jury panel. So she's got that. She's claiming that, she didn't get, by the time she got evidence, there wasn't enough time for her to go through it. And now she's seeing some maybe contradictory statements in witness statements. And she's like, I should have been given the opportunity to present this. Oh, no, by the way, even if I wasn't afforded the opportunity in a timely manner to, have this evidence in my hand, and maybe Brian could have testified. Oh, by the way, Mr. Bill Thompson, as the prosecutor, look at these reports. These are exculpatory. You had an ethical obligation under Idaho criminal law to present even that information, that exculpatory information, to the grand jury at the same time that you're presenting inculpatory information. So she's looking. It's a Hail Mary pass. She's throwing up. It's like, it's like 30 seconds left on the clock, and you've got 4 downs, and you got to go 90 yards for a touchdown, for a winning touchdown. You're throwing a bomb every single time. This isn't no running plays. We are going to throw the bomb, see what we can get. You never know. You might get pass interference, and the ball's moved down, halfway to the goal line. This is just that sort of desperation. She's probably sitting there saying, and look, anything and everything that she could claim is exculpatory, she will claim is exculpatory. That's her ethical obligation. Whether or not we think it's, as you guys know, as investigators, and as the judge, I'm thinking is probably going to say, no, sorry, Ms. Taylor, no. You were notified. Brian had the ability to testify. Now, what she would love is turning over mountains of evidence to her, having to go through it now, time to go through it with Brian Kohberger, and then figuring out a time, could he then, knowing all this information, could he then make a good presentation to the grand jury? That's wonderful, but it will take we won't get to a trial for 10 years. That'll never work in our system. This is a system that's got to keep moving on. Grand juries are not, these are systems, parts of the system that are controlled completely by the prosecutor. There's not going to be a contest between prosecuting attorneys and defense attorneys in front of a grand jury. That's not what the grand jury is used for. But look, she's making her good faith arguments, but I don't think it's going to come to anything. She'll always have that right to appeal later, so for as far as the defense is concerned, all won't be lost. She'll always have one more opportunity later.
Phil, I got to ask you something.
Go ahead.
With all of what's going on here, the defense, in our opinion, again, from our law enforcement perspective, I like to say that, we're seeing a little bit of a stall here, a stalling offense, a Hail Mary pass, to use sports metaphors. How important is it that the judge in this case is a strong judge, not only in demeanor, but of course, in knowledge of the law and in application of the law, keeping in mind that if he makes a mistake or leans one way too much or the other way too much, it opens up the door to appeal. You want to speak upon that?
Absolutely, Billy. Very important point that you're just bringing up. I'm glad you asked me that question because I wanted to make a point about it earlier. What Mike said, when we're going to have rulings, like specifically if she's going to put forward that she wanted to have her client testify, wasn't afforded the opportunity, perhaps the judge say, okay, I'll have the hearing and make a decision. And his knowledge of the law is going to be super important because, again, very, very important. We would hate to see that this case goes to trial. We get a conviction, and now there's 7 or 8 different things that you can have the case overturned on an appeal. And an overturned case 5 years from now, 10 years from now, would be much harder to try as opposed to right now. Witnesses could possibly move away, pass away. There's a lot of different things. Evidence could be lost or destroyed. So that's why it's imperative that the judge is on his big A game here on this case. And again, I think this double-edged sword with this defense attorney Ann Taylor, the double-edged sword is this. She's doing a good job Mike, you brought it out earlier. You said she's worked on capital cases before. She needs to do as much as possible, because the double-edged sword is this: it's going to preclude things down the line that could possibly be where the case, things are brought up at an appeal and the case can be overturned. So everything that she's doing, and I want the audience to understand, they shouldn't hate her. She's doing her job. She's representing someone that's been accused of 4 horrific crimes, and that person needs a defense. And the things that she's doing are actually going to serve us when it gets to the appeals process. If she does everything by the book, dots her I's, cross her T's, and if she makes arguments about the grand jury, that's something that won't be able to be brought up down the line in an appeal. So I think it's kind of a double-edged sword, and I'm glad that he has the defense that he has, because I would hate to see something like this overturned down the line if we do get a conviction, which I believe we're going to.
You know, I remember as a young cop, I was so antagonistic against the defense attorneys. Like, I couldn't even, when we rode
They're
in
the
the
other side,
elevator,
of course. They're the other
when
side.
we rode in the elevator with them up to the court, I just stood on the other side. I almost wouldn't say good morning to them. In fact, when I was on the stand, they would say, "Good morning, officer," or "Good morning, sergeant." I'd be like, you know, I would just nod my head. I wouldn't say anything. I was like, that's really not the way to be. It's really, you got to sort of understand that they have a job to do. You have a job to do. And even though what you were reminded that this is a horrific case, when we talk about all these legal issues and the legal isms and the legalistics of this stuff, we have to remember that the bottom line is 4 people here that lost their lives, you know.
Absolutely.
Ethan Chapin, Zaina Knodel, Madison Mogan, and Kaylee Gonzalez. They're no longer with us. And we're talking about, you know, the niceties of jurisprudence, you know, and whether one side is stalling and the other side is, you know, holding back exculpatory evidence. And we're here to talk about this, you know, and those 4 people are not, you know. And so the great Vernon Gebeth, who wrote the book Practical Homicide Investigation, he starts out saying, "We work for God." You know, in essence, the investigators speak for the deceased, and they work for God that tries to find out and hold accountable the person or persons who did this.
Absolutely, Billy, and I agree with that. A lot of times we've used that term, you know, where we're here for the victim. We're here for a person that can't speak for themselves. They've now been murdered, and we're going to speak for them. And people that don't believe in God, look at it that way. People that believe in God, I think 100% we're doing God's work. I agree with that 100%, Billy.
Absolutely. Let me just play a little bit more of this, and then we'll move on from this.
Jury, because that's his right. When Trump was given the right, he sent one of his lawyers in New York State Court. Here, they could have presented a whole package to the grand jury. I will tell you, going back 20 years, when Michael Jackson, when I was notified that Michael was going to be indicted, I presented and brought, along with Ben Brofman, binders worth of exculpatory information to give to that grand jury so that they would know that before they indicted Michael in that case. So she's laying the groundwork for a motion to dismiss. And what she's asking for, pause this thing. We want a timeout, basically, so we can assemble the information that we would have presented to the grand jury.
I got 30 seconds left, but since you brought up Michael Jackson and you were, you know, his attorney, this complaint about media saturation, that you can't possibly get a fair grand jury, you can't possibly get a fair trial, all this stuff. You know, I look at OJ, acquitted. Casey Anthony, acquitted. Beretta, Robert Blake, acquitted. And of course, your guy, Michael Jackson, in one of his trials, acquitted. So I'm getting a little tired of hearing that you can't get a fair process just when there's lots of media attention. What do you think?
You know, something she led us right into the hornet's nest. Because they got off doesn't mean it was a fair trial. And it doesn't mean that the media didn't affect the outcome of it.
Doesn't mean they were innocent. Doesn't mean they were innocent.
No, exactly that. I mean, I think that if you polled 1,000 people, 950 would say that OJ was guilty, you know, and that doesn't matter. He was found innocent. But, you know, there's other things that came into that case. And I really 100% believe that the broadcast media affected that case negatively. I really do. I think that
100%.
Everyone was playing to the cameras. It was like theater. If the glove doesn't fit, you must acquit. OJ trying on that glove and showing how it didn't fit his hand. All these different things that the people involved in that case played up to the cameras. So Ashley Banfield saying, of course, she wants media coverage to go on with this case, but to name 4 cases that the people got off does not mean they were innocent, and does not mean that because the press was there, they got a more fair trial. I really like to hear your thoughts on this.
Go ahead, Mike. You go first.
Oh, well, yeah, Ashley Banfield is being a little hypocritical because she lives in the media storm, the eye of the media storm on these cases. Without the media storm, she might not be having the job she has right now. And these are the top of the wedding cake, cases that we talk about where the public is very, very interested. They unfortunately don't, or fortunately or unfortunately, depending on how you see it, they don't really represent the average Joe Schmo in a trial, in a case. And they are the ones where you have the $1 million celebrity attorneys that are. I remember reading Chris Darden's book, In Contempt. He was one of the assistant prosecutors to Marcia Clark. And he was saying that they were spending, the O.J. Simpson team was spending more money in his defense than the prosecutor's office was spending prosecuting him. And he found that to be very unsettling. So, yeah, there's always criticism of these high-profile cases, but they really don't represent the average case going on in America, at any given time.
Yeah, you just Phil. Before you, I just want to say something quickly. The average homicide case in Manhattan, I think, takes anywhere from 3 to 5 days.
I was going to say about a week.
Yeah, 3 to 5, and this is going to take, a year and a half, maybe. I mean, if you started the clock when he was arrested, and then already it was December 30th, so you can start the clock. But this case is going to take pretty damn long compared to the average homicide case in a place like New York City. Get Phil.
Well, what I was going to say about the media attention, Ashley Banfield obviously has an agenda. I like her. I think she's a really good journalist. I watched her show. We've been on her show. We've had her on our show. And I think that her agenda is that she wants the media coverage as much as possible because it's going to give her more to talk about and her, maybe better ratings or whatever. However, I just feel that in most cases that aren't getting high media attention, the jury system works pretty good. I think it's not perfect, but it works pretty well in this country. Even if there is a lot of media attention, if there's cameras in the courtroom, there's a lot of evidence here. I think that the jurors will be able to sort through all the noise. Perhaps a witness could get rattled on the stand, but I think that the jury is going to be able to, when a person testifies, the prosecution on the prosecution side, they put up the evidence, they talk to them first, then they're cross-examined by the defense attorney, and then there's redirect, which is the prosecutor gets to talk to that person. So sometimes if a person gets rattled, the prosecution can now redirect them and straighten out some of the things that may have looked like inconsistencies. The point I'm trying to make is that the jury's going to be laser locked on these people, these witnesses. They're going to be able to filter through the noise. They're going to be able to do their due diligence. They're going to be instructed by the judge. There's going to be opening statements. There's going to be closing arguments. And I think that the jury's going to be able to sift through all of this and come up with the right verdict. As far as the media attention, I don't think there should be cameras inside the courtroom only because of the things that we've stated before. And Bill, I think you agree with me that sometimes it's such a big focus. It can make a person get rattled and maybe have an inconsistency during testimony. And an inconsistency is that's the kink in the armor that the defense attorney looks for to make a person look like they're not telling the truth or to challenge evidence. So again, in my opinion, I don't think there should be cameras, but if there are, I think the jury will be able to filter through all of that and get to the bottom line on this case and come up with the right verdict.
I just wanted to also segue at this point to what the media has been complaining a lot about. And that, of course, is web sleuths. And this really bothered them. And in a way, it sort of humors me a bit because they claim to be, of course, the voice of truth, justice, and the American way. And they're not always that. And I agree there's been a lot of noise coming from social media, but some of it does come from them also.
What's it like covering this case with all these random people claiming that they had uncovered something about it?
Yeah, Diane, that created a real challenge, right? But the issue is that because authorities weren't saying a lot, there was this information vacuum, and it had to be filled, and it ended up being filled with these internet online sleuths with these wild accusations, and it became noise for me that I had to ignore. You know, Diane, we deal in facts here at ABC, and we're proud of that. And so you just have to ignore that noise. But I think what Maria pointed out so poignantly there is that these accusations that go into the internet, that go into the world, are not without real consequence. And when there's all these tips pouring in and authorities have to create a separate FBI call line just to sift through these, it takes a lot of time away from that investigation.
So, Kenna, what do you make of the impact that social media has had on this case and the actual investigation? And how do you then balance that with the fact that in cases like this one and many others, police do need the public's help and ask for it outright?
Absolutely. I mean, Dan, we've seen cases like Gabby Petito, right, where people actually do help, right? They find a tip, they help solve the case, and sometimes this unfolds on social media. There really can be a benefit to that. But again, because there was so little actual information on this case in Idaho, these, online detectives really took off with, again, these wild accusations. And I would say it was really hard, particularly on the families, to hear some of these accusations. And sometimes they were at the forefront of that. And
I just want to say also that what she's saying is true, but at the same time, the regular broadcast media does the same exact thing. And they put out things out there that also are not true. And I remember, look, a sergeant in homicide for 10 years, my last 10 years, when the media put something out there, we had to go investigate it. Even if it was so off the wall, we had to slam the door on it. And we were like, why is the media deciding what we investigate? But it was like out there that you had to slam the door on what the media was saying. So in the same way, what this reporter is talking about is that it caused the police a great deal of extra work, having to clear people that had absolutely nothing to do with it. We all remember the boyfriend of Kaylee Gonsalves. Early in the investigation, people were pointing to him as the killer. So, yes, ridiculous things. And yes, social media, specifically YouTube, Twitter, all of these things, Instagram, they all have contributed to, pointing the finger in the wrong direction. Let's put it that way.
Billy, the journalistic threshold used to be that if someone had information on a pending investigation, they would try to corroborate what that person was saying. With social media now and podcasts and different things like that, it just seems like that threshold is much lower now. If somebody says something, they're going to report it. And I don't think that that's very, they're not taking responsibility for their actions when they do that, because they cause a firestorm, which we know there were several in this case, where a guy who was walking his dog and made some comments about the case, they had him as the killer. And he had to carry a firearm. He was getting threats and things like that. We know the bartender, his name was mentioned, and he was the killer. So again, a lot of journalistic thresholds that used to be in place years ago, they really have come way down. The standards have come way down. I don't know if it's cause of social media, but I just think that, there's a lot of things have to be vetted. Just because someone says something doesn't mean that it's gospel or it's true, and it used to be that. And what we do is when person tells us something as investigators, just because somebody came into the 60 squad office when I was in Coney Island and told me something didn't mean I believed it right off the bat. There had to be corroboration for it. And we would, follow it up and say, all right, this is good evidence or it's not good evidence. So again, the journalistic standard seems to have gone way down.
I think that the media used to have a policy that they wouldn't go with something unless they had two independent sources.
That's correct. That's
that they could verify. But if you guys remember, there was a information from People magazine that they said that Brian Kohberger used to go into the Greek, the Happy Greek restaurant or something. I believe that's what it was called. that Kaylee Gonzalez and Madison Mogan worked as service at.
Yep.
And News Nation went with it. And we weren't at all convinced that it was true. And then it turned out to be false. But they had already gone with it. And how much vetting, I guess, because People magazine, they had a former server or waitress that said that, gave basically a story that was not true. And all the media outlets, not all, but many of them went with that story.
How about the Tawana Brawley case? Going back in history. I mean, that's a long time ago, but the Tawana Brawley case was a case that Al Sharpton put forward that a young girl had been raped by a prosecutor in upstate New York. So I believe it was in Yonkers or someplace upstate. And it turned out to be totally false, and the media was all over it, and there was lawsuits that
it was Hopewell Junction was the name of the town.
Okay. Right, okay, and we know that it was proven to be false. There's pending lawsuits against Al Sharpton and Tawana Brawley by, I can't think of the prosecutor's name, Pagonis, I believe, Stephen Pagonis.
Yes, Stephen Pagonis. Yeah.
So again, that was a case that was sensationalized in the media. It was all a complete and total lie. Everything was made up. It was never vetted. And little by little, when the prosecutors and the investigators were able to uncover that it was lies, she moved away. And, currently there's pending lawsuits against it. There's judgments against her and Sharpton, I believe. So again, we can have conspiracy theories run wild and ruin people's lives. I mean, Pagonis was painted as a rapist in those days and wasn't true, 100% false.
Absolutely. Let me play a little bit more of this here. And
all the time, Diane, I think about Jack. I think about Kaylee's ex-boyfriend, who is still very close to her and her family. And the amount of accusations thrown at him were extremely detrimental. And this is a young man who was grieving, and he was hardly allowed that process.
I'm sure what a difficult, unimaginable process for him and the whole family.
Yeah.
Kana, your podcast, The King Road Killings, takes a deep dive on this story. So what can listeners expect to learn about it?
So, Diane, as we cover stories, it's kind of rare that we have the time and the space to pull at every single thread that we want to. And this podcast allows that. It also allows for people to open up in a different and unique way than I've ever experienced. And so over the last 7 months, we've been talking with our sources. And so people who have been following the story really closely are going to hear new interviews. They're going to hear new details. But if you haven't been following the story closely, we will get you caught up very quickly. You won't be left behind.
So, Kana, where does the case stand now?
Right. So a reminder to everybody that Brian Kohberger's parents were subpoenaed by a secret grand jury in Pennsylvania, where he grew up. The next thing that's happening is tomorrow, in all likelihood, Brian Kohberger will be in a Latah County courtroom again. This is because of the gag order that Gonzalez.
All right, I don't think we need to cover this any longer. But look, one of the things I just want to mention something about the coverage of this, and we try to do our best to keep it real and not to report the sensational. Even though I'm sure you can get more clicks, get more views if you report the sensational. We try not to do that. We try to keep that to the facts. But also the allegedly professional reporters like her. Look, she's got an advantage. She's boots on the ground, and people are going to them because they have those 3 letters ABC next to, and they believe instantly trustworthy. I'd also like to remind everyone there's already been 2 books put out on this case. I just saw it on Amazon, and there's 2 being written, one by James Patterson, a noteworthy best-selling author, and one by a writer who used to write for the New York Times by the name of Howard Bloom, who's put out 4 excerpts of his book on in a magazine. So at some point, he's going to finish this book either before the trial or during, or they probably should wait till the conclusion, but they may not. They may put these. So think of all that coverage and how much, and we've covered some of the writing by Howard Bloom, and some of the things that these folks write is their interpretation of things and not necessarily the truth. Mike.
Yeah, Billy, the public information, arena is not like it used to be 20 or 30 years ago. You have people, making their own podcasts. You're making podcasts. We're guests on your show. You and Phil. And so, we try to vet things, and we try to come at stories from a professional police investigation point of view. But there's a lot of people who don't have information at their fingertips, don't have people coming to them, and all they're interested is in clicking, clicks, and they're coming up with wild theories. They're getting second and third hand information. They're not vetting anything. They don't have, as Phil rightly pointed out, and you pointed out, there used to be journalistic thresholds where you had to have one or two people verifying the information, or no matter how tempting it was and how salacious it would be, you wouldn't even dare print it, because you had that sort of threshold that you couldn't overcome. Those standards have gone out the window a long time ago. We saw it with as you said, Phil, with the Tawana Brawley case. We've seen it over the years just deteriorate, and so it makes it very difficult for the police, because and especially in this case, the gag order made people go insane with wild conspiracy theories. And that actually did a tremendous disservice to the public. It would have been better if the gag order had been in place and people had just taken a step back and not reported on this the way they did. But they didn't take it from a professional perspective. They took it from a rumor perspective, and anything and everything. It was the bartender, it was the food truck guy, it was the college professor, the university professor, It was the ex-boyfriend. It was terrible, and it really makes people doubt the usefulness. And there is a tremendous utility in the internet.
One other quick point I wanted to make: when newsrooms get information, whether it be print or whether it be television broadcast, you always see those TV screens in the background. They watch the other channels. So if someone has information, they're not sure if they're going to put out, let's say it's ABC or CBS or whatever, but yet Fox throws it out, boom, they're all over it. So again, I think that's what happened in this case, specifically with the food truck guy and different things like that. They took that little excerpt, maybe 20 seconds of a video that was probably 2 or 3 minutes long. It did look suspicious, but they put it out there, and everybody was saying, wow, this guy's the guy. He was following him. That's the murderer. Turned out to be 100%, false. He had nothing to do with it. He was actually along with the girls. He was friends with them, and he was an acquaintance. So again, the journalistic standards, they sometimes will hold back. But if another, a challenging broadcaster puts it out, they're right on it, and they put it out too. Joe Murray, attorney at law. Now, listen, everybody knows that Joe Murray is a big supporter of police off-the-cuff real crime stories. We've had him on the show numerous times. He is a terrific criminal defense attorney in the New York area, and he's also a retired NYPD member. He had 15 years with the NYPD before he went into his law practice. If you need to reach Joe, and I suggest that everybody should put his phone number into your phone, he can be reached also by his website, which is jmurray-law.com. His telephone number is 646-838-1702, or you can email Joe at jmurray-law.com. Joe could be an advocate. He's also in the criminal defense field, so just feel free to get a hold of him if you need be.
Folks, it goes so quick when you're sort of having a robust discussion with two other gentlemen besides myself that are very knowledgeable in this field. And it seems like we scratched the surface of this whole grand jury concept of trying to overturn the grand jury true bill, the grand jury indictment. And it's really a very in-depth legal conversation needs to be had, because I've watched some of the other attorneys discussing this, and a lot of it is gray area, and some of them don't even know the answers to this. And again, like Phil said earlier, some of these things will have to be decided by a judge. What is the judge going to rule on this? And again, keeping in mind that the judge has to be extra careful, because this, of course, is a death penalty case, and any ruling he makes could potentially give reason for an appeal. And so for that reason, but at the same time, the judge can't lose his persona or his ability to be a judge and to make difficult decisions. the judge has to do that. Guys, we're about an hour, almost an hour and 15 minutes. I'm going to give Phil, I'm going to go to you first. I'm going to give you last thoughts, and I'll go to Mike. We'll have last words. Phil?
Last thoughts. Anytime I do last thoughts on this case, I always like to mention the victims' names: Xana Kernodle, Kaylee Gonzalez, Madison Mogan, Ethan Chapin. May God bless their families and may their souls rest in peace. These kids were slaughtered by an animal, and let's hope justice is served sometime real soon. A quick shout out this Saturday evening on the Oxygen Network. I mentioned this the last time we were on. Bill and I both did separate segments on New York Homicide. It's a new show that's on the Oxygen Network, June 24th, 9 p.m. It's a terrific case, probably the best case I ever worked on in the NYPD. It was a retired sergeant, Sergeant Zink, that was killed. It turned out these guys had killed several other people. They were like serial murderers. It's a great case. I hope you guys tune in and check it out. The Oxygen Network at 6:44 on FiOS. Look it up, 9 p.m., June 24th this week. And I know Bill's did an episode that'll be coming up sometime in the future as well.
Very good. Mike, final words.
Oh, just for the viewers to have patience, and just remember that in this kind of case, Bill Thompson in the district attorney's office, they have dotted every single I, they've crossed every single T. They're not going to leave anything to chance. And even if the judge says they did something improper, it doesn't mean that, Mr. Kohberger is going to be walking the streets anytime soon. And so therefore, put away don't listen to some of the wild conspiracy theories that they might read about or hear about from other people. Just have faith in the system, that the system will work. It works, thousands upon thousands of times every day. And people don't even hear about these cases or see them in the media, but they do. And so therefore, have faith in the system and have patience.
Father Geary, I almost want you to hear my confession after that.
Hey.
Billy, I got to mention one thing, Billy. I noticed somebody put in the chat that Duty Run is going to have Barbara Butcher on in 15 minutes. I think everybody should go over and check that out. That's probably going to be a great show. And happy birthday to my cousin Lenny from LMB Spumoni Gardens. Today's his birthday. I'm going to go over and have some cake with him in a little while. So happy birthday, cousin Lenny.
Yeah, actually, thanks, Phil, for reminding everyone. Duty Run, 8 o'clock, he has the great Barbara Butcher, whose book is coming out, What the Dead Say, I think it's the title of it. But we're actually going Thursday night to her book signing in Brooklyn, New York. Folks, I want to thank everyone for tuning in tonight. It's we were off the air for maybe a week or so, maybe not even that long, but it seems like it was about a week. But
it did seem long. You're right.
Sometimes life gets in the way, and you actually don't have a chance to do the show. I don't do a show on a specific schedule. But I want to thank all of you guys, because when we do come on, you guys show up and you're here and you support us. And I want to thank you guys, all you fans, subscribers, and friends for supporting Police Off the Cuff Real Crime Stories. Have a great night, everyone, and God bless.
Stay safe, everyone.
Good night.
One episode just ain't enough.